If you don't mind, I will speak in English because my Spanish is very poor. It's a mix between Portuguese and Spanish, and you won't understand anything. So I think I won't add anything else than what was already said, but I think it's important to share with you our perspective as an NGO based in Portugal. And why is that an NGO based in Portugal is so keen to work on asset recovery and victim compensation? You would say regarding Angola, and this is the most common thing that I heard quite often, is because I was born in Angola, but it's not. It's important to say that for us, of course, the end goal is to give the money back to the legitimate owner, which are the victims of corruption, the people, but we are also aiming for stopping illicit financial flows coming to Portugal. We think that's key also to protect the Portuguese economy and European economy, to prevent money laundering via banks and real estate purchase, such as in golden visas and other scandals, to protect the rule of law and democracy. Sometimes we forget that corruption also has a very strong impact on the democracy and the rule of law. And for example, in Portugal, since we are always listening about corruption scandals, most of them involving kleptocrats based in other countries, people are starting distrusting institutions and policymakers, which makes populists to rise. And that is also preventing our, affecting and damaging our democracy. From an economic perspective, Portugal is a very small country in the European sphere. We are too dependent on EU funding, and we are also too dependent of foreign investment. And that's why the country is an open door to everyone that wishes to invest. It can be through real estate, it can be through bank purchase, such as happened with Isabel dos Santos, the daughter of President dos Santos, he died a few months ago, but in the end, Isabel dos Santos, that some of you will know from the Luanda Leaks case, she was able to buy a bank in Portugal, although she was a politically exposed person. She was able to buy shares in most key sectors of the Portuguese economy, and of course, that has a strong impact because, for example, one of the companies she owned was nationalized by the Portuguese state, and now the state is paying because no one wishes to buy that company. On the same time, if you think about the strong economic crisis that the country faced, we were subjected to support from Troika, which was the IMF and the central bank. It was because of BES. BES was one of the biggest banks in Portugal, and BES collapsed. And behind the bankrupt of this bank was the investments of BES in Angola, BESA, the bank. So there was a sovereign guarantee that was issued by the Angolan regime, and then the Angolan regime decided to dismiss completely that sovereign guarantee, and we're still paying, we, Portuguese people, were still paying for the deals that were made by BES pretty much everywhere in the world, not just in Angola. So just to be very brief, because I know tomorrow we will dig into this, in general, the asset recovery framework in Portugal follows the one from the European Union. One good news is that the Public Prosecutor's Office just released information and data saying that Portugal is now able to recover assets based on judicial cooperation established with countries such as Angola. And for example, since 2020, the number of assets that were freezed and recovered were increased significantly because of the Luanda Leaks case. So if we have a big case related to money laundering or illicit financial flows, it is good at least to think that the Portuguese authorities are able to recover more money based on the information that these cases are releasing. One of the things that I can share with you, because I think maybe it's important also for Venezuela, is the Luanda Leaks case. We started working on the case because it's a huge corruption scandal, and because we thought as a good opportunity to start discussing asset recovery, victim compensation, but everything else that I said earlier. So, under the judicial agreements established between the Angolan state and the Portuguese state, Portuguese authorities have seized bank accounts, for example, in Eurobic, and shares from Isabel dos Santos in those companies. But there are no info related to criminal charges against Isabel dos Santos. So lack of information is also a key element of our work in Portugal. It's very hard to be able to find what are the cases that she is involved, if there are civil cases, if there are criminal investigations, because as you know, most of these investigations are under secrecy, and they take long time. So it's not always easy to engage in strategic litigation, like you were saying. So we need sometimes strong investment in terms of investigation, being able to investigate, and like Francois was saying, to have access to data. Otherwise, it will be pretty much impossible for us to litigate with impact. And there were, of course, cases against audit firms, because of the role they had in allowing all these schemes. But until now, nothing significantly happened, to be honest, related to Luanda Leaks case. Why? Because there's no supervision authorities like the Portuguese Central Bank. They don't do anything. The governor of the Portuguese Central Bank once went to Parliament and said, well, we identified flaws, but it's just our role is to identify flaws, it's not to solve those flaws. And for example, Eurobic, which was the bank owned by Isabel dos Santos, the bank didn't have any compliance system in place. And it continued to operate until 2020. And that's so we are now getting access to these audits, not being published by the Portuguese National Bank, as you can imagine, but at least we can see exactly what went wrong and what was allowed. Nobody's stopping the enablers. I can tell you, for example, that some of the lawyers that assisted Isabel dos Santos in all her deals, now they just launched a new law firm, and they continue business as usual. And to be honest, and sadly to say, Portugal continues to be somehow a money laundering paradise, and I don't say it lightly. You can imagine that schemes like golden visas are allowing money to get into the country that nobody knows what's its origin. The Portuguese authorities related to golden visas specifically, they say we don't have due diligence in place. This is said openly, so that's why we are against golden visas. We are also providing citizenship for Russian kleptocrats through a very specific regime. So what I'm saying is that it's not just the country doesn't care about AML regulations, because we are a country from the European Union. It's just that we need the money. And that's the overall thinking behind it. So we need the investment, we need foreign investment, so we'll keep everything loose so that we don't lose the money that we need so strongly to survive and to sphere. But then, of course, now you're seeing the problems that we're having in housing markets, because it's impossible to find a house in central Lisbon, mostly due to foreign investment through real estate purchase. Regarding strategic litigation, very briefly again, in Portugal, a victim can appear as a party to criminal proceedings. It's assistente to the case, so it's very specific way of civil society organizations to participate in cases. It's not in all cases, only in some cases, but it's possible. But it's also possible for civil societies to engage as a civil party, so in civil procedures. And I will briefly explain that. So in criminal law, as assistant to cases, we can offer evidence, request specific actions to be taken by the court, or request the opening of the investigation phase if we disagree in something. In the end, we are assisting the public prosecutor's officers or assisting the court in finding truth. So it's a very good position. But for example, for an NGO as Transparency International Portugal is not straightforward because we don't represent the victims, okay? And this is a bit tricky sometimes. In civil law, there is a way we can participate in civil proceedings to recover assets via ação popular. This I don't think was ever tested, but we're willing to do it, maybe with our colleagues from Venezuela. So we have the legitimacy to file a popular action in civil court to prevent the loss of assets if these are deemed misappropriated assets belonging to the Portuguese state. So only if it belongs to the Portuguese state. When sometimes we hear that you in Portugal are not doing anything to assist asset recovery, you need to understand that we're talking about illicit financial flows coming from other countries to Portugal. If we can prove money laundering, or if there are corruption charges in the country of origin, everything is easier. But if it's not, it's much harder. One of the things that it's a new approach that some international organizations like the Basel Institute and I think also the US State Department are thinking about is civil litigation. So we can go to court, present a civil complaint, but for that end we need to privately trace the assets, and this is very hard. So in criminal proceedings, we rely on the public prosecutor's office or in the asset recovery unit from judiciary police to trace the assets. In a civil action, what happens is that we need to say, well, this is money coming from an illicit fund or origin, and that's why the assets needs to be seized or freezed, whatever. So it's much harder. That's why we need central registries of beneficial owners and access to information coming, for example, from investigative journalism. So, in general, asset recovery claims under the civil law must meet the following requirements. Very briefly, based in an unlawful conduct, we need to say this was an unlawful conduct, which is sometimes difficult to prove, demonstrating that someone is guilty of misconduct, present a causal link between the conduct and the relevant damage. We need to say, this happened, and because this happened, this is the damage that was created to the people or to the country, and demonstrating the damage suffered. What is the actual damage? So it's difficult to go on this path. So very briefly again, 2 minutes. Common obstacles according to the different stages of the asset recovery cycle based in our experience dealing with the Luanda Leaks case. Regarding asset tracing, first, what triggers investigations in cases? People in the judiciary, they don't start investigating because we say, do investigate. Something needs to happen, right? So either is a request coming from the country of origin, from Venezuela, from Angola, from elsewhere, or is an investigative work such as Luanda Leaks or other stories that are coming from networks of investigative journalists. The other thing are the enablers. The enablers, such as the lawyers, they are protective under professional secrecy. So, for example, public prosecutors, they cannot ask information from lawyers and get it, because they can just say, well, this is legal protective because I'm representing this person or that person. One of the things that we are now contesting in Portugal is the role of lawyers, not as lawyers, but as consultants, which is a completely different thing. Law firms are acting as consultancy firms. They're not acting as lawyers. And on that capacity, they don't have, they cannot benefit the same, standards as if they were representing their clients in the court of law. It's a completely different thing. Asset freezing. There's also an obstacle. A judge needs to validate the request made by the public prosecutor's office and say, yes, it's true that these assets need to be freezed. It happens in the Luanda Leaks case. There was this judge that decided that the shares from Isabel dos Santos and Inerobic shouldn't be freezed because she could prove the money, the flows of money coming from Luanda to Lisbon, But, for example, one of the companies that she was using to channel these funds belongs to a close friend. And the judge said, well, it's not a close friend, not a business associate, it's a completely independent company. If you go to Luanda, everybody knows who owns the company, and everybody knows that belongs to a friend. But the judge decided that, and now the public prosecutor office is now contesting that decision, but we need a judge to validate it. Other thing is that not all countries of origin of illicit financial flows are fully cooperative, like Equatorial Guinea, right? So it's not so easy to have access to that information. Asset confiscation, we need conviction. And again, it takes a long time, and cases can last more than 10 years easily. Asset return, and here is the point regarding the victims. I think we need to better understand, if we're talking about the victims, who represents the victims, and who can recognize the victims as victims, who can certify that these are victims' representatives and these are the victims of a certain case. It's not so straightforward as we can imagine. It's not easily to do it. So what we can do, I think I totally agree, we should test litigation every time we can, everywhere. Don't forget to chase the enablers, use sanctions regimes like GLOMAG, and, for example, use the OECD anti-bribery framework. I think it's also important because we have companies based in the global north doing business with these people, the ones that are stealing the money. Strengthen cross-border cooperation. Like Tutu was saying, we have a network of civil society organizations belonging to the Portuguese-speaking community, so Lusophone countries, to exchange information, to develop capacity building, and also to do, advocacy work together. Promote and assist investigative journalists, raise public support by telling stories, linking corruption and human rights. Here, I think we need to be more specific. It's not just thinking about human rights, it's to be really specific. The money was stolen and people here lost their houses, or people here don't have access to sanitation, because it's better to explain who are the victims, concretely. Right? When we talk about corruption, we're talking about corruption, about damaging everybody, everywhere, and all the citizens. But for example, strategic litigation works very well in environmental causes, because we can easily identify the victims. Blame and shame. I used to say that Isabel dos Santos, she was not arrested, but she's living in her golden cage in Dubai, and she cannot travel anywhere. So it's a good thing to blame and shame. Engage the diaspora, of course, and also engage migrant communities. Maybe it's a good idea for Venezuela. We have a lot of Portuguese people in Venezuela, Luso-Venezuelans, we can say. So it's a good opportunity to discuss the Venezuelan situation in Portugal, because you have a lot of people coming from Venezuela again to Portugal, flying away. Leaving the country because of corruption, leaving the country because of the poor conditions. So engage them as well, expand whistleblowing protection, of course, and finally demand accountability. I think we should start demanding accountability not only to our governments, but like institutions like the IMF or the World Bank, because these institutions are giving money to kleptocrats, like in Equatorial Guinea, like in Angola and everywhere, and also the European Commission. For example, we have 2 projects going on in Equatorial Guinea, which is good, because at least we can provide some support to our colleagues there, but in the end, the European Commission doesn't want to talk about corruption, or asset recovery, or returning the stolen assets. They're saying you need to promote human rights. But is it possible to promote human rights in an environment and in a country that completely dismisses political and civil rights, that chases people that are on the streets, that makes political parties illegal like that? So I think we also should demand accountability. Thank you so much.